All right, buckle up, Buttercups, and welcome back to the Deep Dive, where we take the gnarly, the naughty, the what in the constitutional heck, and try to untangle it just for you.
We do try.
Today, we're plunging into a book that's less bedtime story and more legal thriller. Phil Hart's Constitutional Income. Do you have any?
It definitely gets you thinking.
Now, before your eyes glaze over, stick with us. This deep dive into Hart's arguments about the U.S. income tax might just make you see your paycheck in a whole new, possibly revolutionary light.
It challenges a lot of assumptions.
If you're ready to have those assumptions delightfully dismantled, go ahead and smash that like button and subscribe. You won't want to miss where this rabbit hole leads.
That's right. We're venturing into territory that can feel, well, like navigating a legal minefield.
Think of it as an intellectual adventure.
Exactly. And who knows what treasures or maybe startling insights we might unearth.
Absolutely. And speaking of intriguing, the dedication of this book really grabbed me. Hart dedicates it to his daughter and her friends, born, in his words, into a feudal system, with a powerful hope that they will ultimately live in freedom.
Wow, that's a pretty strong opening statement, isn't it?
Yeah, it hints at some deep-seated beliefs about the current state of affairs.
It certainly frames his argument with a strong sense of urgency. And it's fascinating to consider Hart's background as well.
Right, he's not a lawyer.
No, he comes from the world of civil engineering and business, so you've got someone with a very logical, problem-solving brain tackling these complex legal questions.
The different lens. It can often reveal angles that maybe those steeped in traditional legal thought might overlook.
Could be, yeah, a fresh perspective.
Okay, so we've got a determined author with a technical mind on a quest for constitutional clarity. How does he even begin to unpack this beast of a topic? What's the roadmap he lays out for us?
Well, he starts by laying a crucial foundation, defining the very terms we use.
Definitions. Sounds a bit dry.
It might sound elementary, but as Hart brilliantly illustrates, the devil is often in the definitional details, honestly.
Okay, I'm intrigued.
From there, he delves into the fundamental distinction between direct and indirect taxes, a constitutional concept that's way more exciting than it sounds. Trust us.
I'm trusting you.
Then we'll journey through the surprisingly dramatic history of income taxation in the U.S., which is full of twists and turns. And of course, we'll spend a good chunk of time dissecting the enigmatic 16th Amendment and its intended meaning.
Sounds like a journey worthy of Indiana Jones, but with fewer snakes and more legal precedents.
Something like that. Fewer snakes, definitely.
Let's dive into this definitional deep end. Hart makes a huge deal about the importance of getting our terms straight. Why does he hammer on this so much?
You see, for Hart, this isn't just about splitting hairs. He argues that in the realm of law, especially constitutional law, precision in language is paramount. It's everything.
Okay.
He throws a real curveball right out of the gate by pointing out that a seemingly straightforward term like United States has an astonishing number of legal definitions.
Wait, really? How many?
Around 450.
450. You could read a whole dictionary just for that term. So it's not just one United States we're talking about in legal documents.
Exactly. Hart uses this mind-boggling number of definitions to highlight how easily the government can, intentionally or unintentionally shift the goalposts.
Shift the goalposts? How?
Well, potentially apply laws in ways the average person wouldn't expect or even understand. That's a key insight into his entire argument. The system, in his view, can be interpreted and applied differently depending on which definition is in play.
Ah, I see. Tricky.
This leads him to the crucial distinction between what he calls constitutional income and statutory taxable income.
Okay, constitutional income versus statutory taxable income. Lay that on us. What's the hardened difference?
Okay, think of statutory taxable income as what the current IRS regulations and tax code define as income subject to taxation. The rules we follow now, it's based on the laws passed by Congress.
Got it. The everyday stuff.
Now, constitutional income, according to Hart, is a much more specific and limited category. He believes it's defined by the original intent and constraints of the Constitution, particularly concerning the federal government's power to tax.
More limited. How so?
He argues that the vast majority of income that's currently taxed, things like your wages and salary, doesn't actually fall under this narrow definition of constitutional income.
Seriously?
My paycheck.
According to him, yeah. And therefore, he argues, it can't be directly taxed without being apportioned among the states.
Apportioned?
Yeah.
Divided up based on population.
Right. He even suggests that something like 3/4 of Americans might not have any constitutional income as he defines it. That's a mic drop moment right there. So how does he justify this rather radical claim? This brings us to the heavyweight battle of direct versus indirect taxes.
Precisely. Hart dives deep into the constitutional requirement that direct taxes must be apportioned among the states based on population.
That apportionment thing again?
He underscores that this is the only provision mentioned twice in the Constitution, in Article 1, Section 2, and again in Article 1, Section 9.
Twice. Why is that significant?
For Hart, this repetition screams out the framers' deep concern about the federal government's power to directly tax individuals and their property. They wanted safeguards. Serious safeguards.
Apportionment. We touched on this before, but remind us why the framers thought this was such a big deal for direct taxes.
Yeah.
What were they afraid of?
Imagine the federal government deciding to slap a hefty tax directly on, say, land ownership, just because you own land.
Okay.
Without apportionment, they could disproportionately burden landowners in one particular state or region. Massachusetts gets hammered, Virginia gets off easy, something like that.
Unfairness between states.
Exactly. Apportionment ensures that the total tax burden is distributed among the states according to their population, offering a layer of protection against such regional discrimination. It was about fairness and, crucially, preventing the federal government from becoming too powerful in its ability to directly extract wealth from individuals.
Okay, so with that safeguard for direct taxes in mind, what's the dividing line between direct and indirect taxes in Hart's framework, and how do wages fit in?
Okay, so Hart argues that direct taxes are levied directly on individuals or their property simply because they exist or own that property.
Like a head tax or a property tax.
Exactly. Think of a tax on the value of your house or a poll tax, a tax just for being a person. Indirect taxes, on the other hand, are taxes on activities.
Activities?
Yeah, transactions, privileges, or consumption.
Yeah.
Sales taxes, excise taxes on goods like alcohol or tobacco. Those are indirect. You choose to buy the thing, you pay the tax.
Okay, makes sense. So where do wages fall?
Hart's core argument is that a tax on your wages and salary is, in essence, a direct tax on the value of your labor.
Because it's hitting the source directly.
Yes. It's not tied to a specific privilege or transaction in the same way. It's a direct extraction from what you earn simply for earning it. He contrasts this with, say, a tax on the profit from a business, which he might consider an indirect tax on the privilege of conducting that business.
And to bolster this, he even pulls out some historical intellectual artillery, right? Adam Smith, the OG of economics, makes an appearance.
Absolutely. Hart quotes extensively from Adam Smith's The Wealth of Nations, where Smith specifically identifies taxes upon the wages of labor and capitation taxes as direct taxes.
Wow, Smith himself said that.
That's Hart's point. He's arguing that the very thinkers who heavily influenced the framers of the Constitution understood a tax on wages to be a direct tax that would require apportionment.
So in Hart's view, the current federal income tax on wages skips this vital constitutional hurdle.
That's the seismic implication of his argument. That's the core issue he sees. He highlights the fact that the word income appears only once in the original Constitution, and that was with the addition of the 16th Amendment.
Only once before that.
Right. He uses a clever analogy, imagining the Constitution having pigeonholes for different types of taxes. He suggests the framers had these distinct categories of direct and indirect taxes firmly in mind when they crafted the document.
Pigeonholes, I like that. Okay, let's time travel back a bit. Hart delves into the history of income taxation in the U.S. before the 16th Amendment. What were those early attempts like, and what can they tell us?
The early history is quite revealing, actually. Hart takes us back to the late 1700s with the excise tax on carriages and Alexander Hamilton's role in it.
The carriage tax. I remember that from history class.
What's fascinating here, though, is that Hart points out how this was, by many accounts, a deliberately staged legal challenge held in the United States, designed to establish that certain taxes could be classified as indirect and therefore not subject to apportionment.
A staged lawsuit. Seriously. There's some serious political maneuvering right there. What was the end game?
Well, the Federalists, who favored a stronger central government, weren't huge fans of the limitations that the direct tax apportionment rule placed on federal power. Understandably, from their perspective.
It tied their hands a bit.
Exactly. The Helton case allowed them to argue that a tax on carriages was a tax on consumption, an indirect tax, thus expanding the federal government's ability to raise revenue without the cumbersome process of apportionment. Hart suggests that Hamilton, who had opposed direct taxes at the Constitutional Convention, had a clear agenda here.
Interesting. So politics and legal strategy from the very beginning. Fast forward a few decades, We had income taxes during some of our big wars, right?
Yes. Hart discusses the temporary federal income taxes enacted during the War of 1812 and, more significantly, during the Civil War.
Civil War income tax.
He notes that the Civil War income tax was largely viewed as a patriotic duty, a necessary sacrifice to preserve the Union. People generally accepted it under those circumstances.
For the war effort.
Right. Interestingly, he mentions that the Confederate Congress also had an income tax. And even more remarkably, it could be paid in kind. Farmers could pay with crops, for example. Because it was a tax on gross revenue, the Confederacy considered it a direct tax.
Paid in crops? Wow. So these were clearly seen as emergency measures then.
That seems to be the case.
What happened to them once the crises passed? Were they just dropped?
As Hart points out, these early income taxes were indeed repealed relatively soon after the wars ended. However, he highlights a crucial long-term impact. These experiences demonstrated the potential of income taxes to generate substantial revenue.
Ah, the government saw the dollar signs.
Well, it's a fact that didn't go unnoticed by those who favored a more powerful central government, even in peacetime. The seed for a permanent federal income tax had been planted.
And that brings us to the landmark, the 16th Amendment. The common wisdom is that this amendment gave Congress the explicit power to tax income, period, full stop. But Hart throws a major wrench in that understanding, doesn't he?
He certainly does, a big one. Hart acknowledges the standard narrative that the 16th Amendment, ratified in 1913, was intended to overturn the Supreme Court's 1895 Pollock v. Farmers Loan and Trust Co. ruling.
The Pollock ruling, that struck down an earlier income tax.
Yes, specifically one that taxed income derived from property, declaring that to be a direct tax requiring apportionment. Hart agrees the amendment targeted Pollock, but then he drops a bombshell of an argument.
I'm on the edge of my seat. What's his contrarian take on the 16th Amendment?
Hart argues that there is a stunning lack of historical evidence to suggest that the American people during the ratification debates for the 16th Amendment actually desired or intended to have their wages and salaries subjected to a direct federal income tax.
No evidence. None at all.
He claims a thorough search of law journals, political economy publications, the congressional record of the time, and major newspapers reveals no widespread public demand for this kind of tax on labor.
That's huge.
It's a truly provocative assertion that challenges a century of accepted understanding.
If the people weren't clamoring to have their wages taxed, then what in Hart's view was the real purpose and scope of the 16th Amendment?
This is where his concept of harmony in legal interpretation becomes central.
Harmony. Like everything needs to fit together.
Yes, Hart insists that all parts of the Constitution must be interpreted in a way that makes them consistent with one another, avoiding inherent contradictions. You can't just ignore one part because another part seems to say something different.
Oh.
He believes the 16th Amendment was solely aimed at addressing the specific issue raised by the Pollock ruling, the taxation of income derived from property, such as dividends and interest. Stuff like that.
So investment income, basically.
Essentially, yes. He argues that it was meant to clarify that such unearned income, once severed from the source, could be taxed without apportionment. Crucially, he contends it was not intended to authorize a direct tax on wages and salaries.
Because wages are different.
Because he views wages as the direct fruit of a person's labor and therefore still subject to the original direct tax rules, including apportionment.
He even suggests that during the ratification debates, the definition of income wasn't heavily debated precisely because everyone at the time understood it to refer to this unearned income from property, not the everyday wages of working people.
That's his argument, that the common understanding was different back then.
That's a pretty bold historical interpretation.
It is. And he reinforces this by pointing back to the Pollock decision itself, where the court stated, taxes on personal property or on the income of personal property are likewise direct.
So Pollock linked tax on property income directly to property itself.
Right. Hart's argument is that the 16th Amendment was a targeted surgical strike to overturn this specific aspect of Pollock, allowing for an unapportioned tax on income from property, but leaving the constitutional protections against direct taxes on labor untouched.
This is really turning the conventional narrative on its head. Wow. Now, you mentioned the Corporate Excise Tax Act of 1909 earlier. How does Hart weave this into his understanding of the 16th Amendment and the income tax?
Yes, the 1909 Act. This is a particularly insightful part of Hart's analysis, I think. He explains that this act, which levied a tax on the net income of corporations, was strategically passed as part of a tariff bill.
As part of a tariff bill. Why?
Well, Hart explores the argument that this act was, in essence, a political maneuver, a way to appease the growing public sentiment for some form of income tax without actually implementing a broad-based direct tax on individual wages.
So it was a kind of compromise, a way to show action on income tax without going all the way, so to speak, and taxing everybody's paycheck.
Precisely, a political calculation. Hart quotes Senator Byrd, who at the time noted the immense influence of certain senators like Aldrich in shaping tariff legislation. Basically, a few powerful people could drive the agenda.
Okay.
The argument is that the corporate excise tax provided a seemingly palatable alternative that those in power preferred over a direct tax on individuals. It taxed businesses, not people, directly.
So politically easier.
Potentially, yes. Hart suggests it was a way to maintain the existing tax structure, which he views as inherently unfair, while giving the appearance of reform. It's a fascinating look at the potential political motivations behind early tax legislation.
So a bit of a legislative dance to avoid a direct confrontation with the direct tax clause of the Constitution when it came to wages. Keep wages off the table.
That's certainly the implication of Hart's analysis, drawing on the historical context and the political climate of the time. He paints a picture of a Congress navigating complex pressures and potentially opting for solutions that served certain interests while perhaps not fully aligning with the spirit of the Constitution as he interprets it.
This is becoming quite the constitutional whodunit. Now, Hart also discusses different classes of taxpayers. What distinctions does he make, and why are they relevant to this whole question of constitutional income?
Right, the classes. Hart argues that the Constitution and the very nature of sovereignty create different categories of individuals with respect to the federal government's taxing power. It's not one size fits all.
Okay, like who?
He starts with a geographical classification, pointing out that the federal government exercises exclusive legislative authority in areas outside the several states, think territories, possessions, and Washington, D.C.
Places that aren't states.
Correct. In these zones, he contends, the constitutional constraints on direct taxation, like apportionment and uniformity, don't fully apply in the same way they do within the states.
Why not?
Because Congress has plenary or complete power there. Therefore, in these areas, the definition of taxable income is more a matter of statutory law, what Congress says goes, than constitutional limitation, as he sees it.
So the rules might be different in, say, Puerto Rico or Guam versus Pennsylvania.
That's the essence of his argument regarding geographical distinctions. He then moves on to government employees, both at the state and federal levels.
Okay, what about them?
Here, he invokes that powerful principle from Pollock v. Maryland. The power to tax involves the power to destroy.
Ah, the famous quote.
Senator Borah himself quoted this during the debates around the Income Tax Amendment. Hart argues that if the federal government can directly tax the income of state employees, or vice versa, it could potentially undermine the independence and functioning of those respective governments.
Like using tax as a weapon.
Potentially, or at least interfering. He extends this idea to suggest that the ultimate sovereign, the people, have placed limits on Congress's taxing power through the requirements of apportionment and uniformity to protect themselves and their state governments.
And the third group he highlights is federal judges. Why did they get their own special mention?
Hart explains that the taxation of federal judges raises unique constitutional concerns related to the independence of the judiciary. It's about keeping them separate.
How so?
Article 3 of the Constitution states that judges' compensation shall not be diminished during their continuance in office.
Right, you can't cut their pay while they're serving.
Exactly. The Supreme Court, in Evans v. Gore back in 1920, affirmed that subjecting federal judges' salaries to income tax would indeed be an unconstitutional diminution of their compensation, safeguarding their impartiality.
So they ruled income tax was a diminution. Interesting.
Yes. Hart notes that later statutes even explicitly exempted certain federal judges from income tax. He raises the intriguing question of whether a judge who is themselves under the jurisdiction of the IRS can truly be an impartial arbiter in tax disputes.
That's a fair question. These different classifications really underscore the complexity and the nuanced relationships between the individual, the states, and the federal government when it comes to taxation. Now, Hart also delves into the intent of the framers. How does he try to decipher what those guys in powdered wigs were thinking?
For Hart, understanding the original intent is absolutely key to correctly interpreting the Constitution. It's not just about the words, but what they meant back then.
How do we figure that out?
He argues that foundational documents like the Federalist Papers and Eliot's debates, which capture the discussions and reasoning behind the Constitution's provisions, hold immense weight, almost on par with the Constitution itself. They're like the owner's manual.
The commentary track.
Kinda, yeah. He quotes of Mr. President, presumably the presiding officer from the congressional record during the amendment debates, who acknowledged, "I do not believe the fathers ever contemplated that income taxes must be apportioned according to population, but the courts have said that they did."
Interesting quote. What's Hart's point with that?
Hart uses this to suggest that even at the time of the 16th Amendment debates, there was an awareness, or at least an argument, that the Supreme Court's interpretation in Pollock about direct taxes might not have perfectly aligned with the framers' original vision, but that the court's view was the one they had to deal with.
Okay, let's revisit a central point of contention for Hart. Wages versus income. He seems to have a real issue with how the government defines and taxes these. It's like the crux of it all.
He absolutely does. It really is central. Hart strongly objects to the broad definition of income often cited by the government, the one derived from cases like Stratton, Doyle, and Eisner, which includes gain derived from capital, from labor, or from both combined.
That sounds pretty all-encompassing.
It does. But he argues that the 16th Amendment only granted the authority to levy an indirect tax on income, specifically income from capital, not a direct tax on the income derived from labor.
So, a tax on profits, not paychecks.
That's the distinction he makes. He defines a direct tax on income as one that diminishes the very source of that income, like a wage tax, reducing a worker's earnings directly from their effort. Conversely, he sees an indirect tax on income as a tax on profit or gain that leaves the original source, the capital, or maybe even the laborer's ability, intact.
So, in his view, wages aren't the kind of income that the 16th Amendment authorized for direct, unapportioned taxation. There's something different.
Precisely. They're the source, not the gain derived from it, in his view. He quotes O'Connell v. State BD of Equalization, which states, "There can be no tax upon a man's right to live and earn his bread by the sweat of his brow."
Wow, powerful quote.
It powerfully illustrates his belief that a direct tax on wages is fundamentally a tax on the inherent right to work and sustain oneself, a concept he finds constitutionally incompatible with the principles of individual liberty.
This is a pretty significant divergence from mainstream legal and economic thought today, isn't it?
Oh, absolutely. It cuts against decades of practice and court rulings.
Now, when Hart addresses modern arguments and interpretations, how does he grapple with the current legal precedents that seem to contradict his views? Does he just ignore them?
No, he doesn't ignore them, but he's highly critical. He contends that the very act of accepting the various exemptions and deductions offered by the IRS inadvertently legitimizes what he considers to be a fundamentally flawed and unconstitutional system, at least as it applies to the taxation of wages.
So, like, playing the game means you accept the rules, even if the rules are wrong.
That's essentially his point. He sees these deductions and exemptions as minor concessions within an inherently illegitimate framework for taxing labor directly.
He even cites the case of United States v. Sitka, which seems to directly undermine his argument, doesn't it? What does that case say?
He does. The Second Circuit in Sitka explicitly stated that the 16th Amendment, along with the pre-existing taxing power created by Article 3, Section 8 of the Constitution, provides Congress with the necessary authority to impose a direct, non-apportioned income tax. Pretty clear statement.
Yeah, that sounds like the opposite of Hart's view. How does he respond?
Hart dismisses such rulings as, well, his term is junk law. He highlights what he perceives as the fundamental conflict between these modern judicial interpretations and his understanding of the Constitution's original meaning and the specific limited intent he sees behind the 16th Amendment.
So he thinks the courts just got it wrong later on.
That's his position, yes, that they deviated from the original understanding.
And in this section, he brings up the idea of jurisdiction in a way that goes beyond just where you physically live, right? This sounds complex.
Exactly. This is another key and perhaps more unconventional part of his argument. Hart argues that not everyone residing within the geographical boundaries of the United States necessarily falls under the same legal jurisdiction for federal income tax purposes.
How can that be?
He uses the analogy of a marriage license. Obtaining one doesn't make you subject to income tax, obviously, but it does bring you under the purview of specific family law statutes.
Okay, different sets of laws apply, based on your actions or status.
Right. He then makes a rather unique argument. He suggests that the federal government, through an act of incorporation in 1871, essentially created a separate legal entity referred to as the United States, a federal corporation.
The U.S. government is a corporation.
That's the argument he explores. He posits that through various interactions, maybe including obtaining licenses, using social security numbers, or entering into certain types of agreements, individuals can unknowingly subject themselves to the jurisdiction of this corporate entity and its specific tax laws.
And those laws are different.
He argues they operate outside or alongside the direct constitutional limitations applicable to citizens of the several states acting in their sovereign capacity. It's about different legal statuses or relationships with the government entity.
The federal government as a separate corporation with its own jurisdiction. That's a concept that might raise a few eyebrows for many listeners. It's definitely outside the mainstream.
It is a non-standard interpretation for sure. And Hart presents it as a crucial element in understanding how, in his view, a direct tax on the wages of individuals residing in the states has been implemented and maintained, seemingly without the explicit constitutional authorization he believes is required.
So the complexity allows this to happen.
He believes the complexity of legal terminology and the multiple meanings of terms like United States contribute to this jurisdictional ambiguity, allowing the system to function as it does.
Moving towards the end of the book, Hart touches on the idea of a flat tax. Given his strong constitutional arguments against the current system, what's his take on this seemingly simpler alternative? Does he like it?
You might expect him to embrace the simplicity of a flat tax, right? Get rid of the crazy code.
Yeah, seems logical.
But Hart actually expresses reservations. He agrees that the sheer complexity and volume of the current tax code are huge red flags, suggesting something is fundamentally amiss. That much is clear.
What?
However, he argues that simply flattening the tax rate wouldn't address the underlying constitutional issue as he sees it.
Because it's still direct tax on wages.
Exactly. Whether it's a graduated tax with numerous deductions or a flat tax with few, if it remains a direct, unapportioned tax on the wages of individuals within the states, he believes it still lacks constitutional legitimacy. The type of tax is the problem, not just the rate structure.
He even suggests a flat tax could be worse.
He raises the concern that a flat tax, by its seeming simplicity, could potentially pave the way for even greater government control over individual earnings, perhaps making it easier to raise over time without complex bracket arguments.
Interesting point. He even brings in a quote from the New York Times from way back in 1911 that seems to support his interpretation of what income meant at the time, doesn't he?
Yes, that's a fascinating find he includes. He quotes Governor A.E. Wilson of Kentucky, who, during the debates on the proposed income tax amendment, stated quite clearly in the Times, "I do not regard his wages or salary as an income that would have to pay its proportionate tax under the new system."
Wow. The governor saying that back then?
Hart uses this contemporary statement as further evidence that the common understanding of income during the ratification era didn't necessarily encompass wages and salaries, at least not for everyone involved in the debate.
Food for thought.
He also reminds us of the fundamental principle, repeatedly affirmed by the Supreme Court, that the people of America are the ultimate source of sovereignty in this nation. Their understanding, their consent, matters.
All right, as we begin to bring this deep dive on Phil Hart's constitutional income to a close, let's quickly recap the core arguments he puts forth. It's been a lot to unpack.
Certainly, it's dense stuff. His central argument really revolves around that fundamental distinction between direct and indirect taxes, and the Constitution's explicit requirement for direct taxes to be apportioned among the states by population.
The double mention in the Constitution.
Right. He firmly believes that taxes on wages and salaries are constitutionally direct taxes on the value of a person's labor and are therefore subject to that apportionment rule.
And the 16th Amendment didn't change that for wages.
Not according to Hart. He contends that the 16th Amendment was specifically and narrowly intended to address the taxation of income from property, dividends, interest, etc., overturning that specific part of the Pollock ruling, but critically did not grant Congress the power to directly tax wages without apportionment.
So the bottom line for him is?
Consequently, he concludes that the current federal income tax system, specifically as it applies to wages earned by individuals residing within the 50 states, operates outside the bounds of the Constitution as originally intended and ratified.
It's definitely a perspective that challenges the the widely accepted understanding of income tax in America and raises some profound questions about the relationship between the government and the individual. Now, for our outro, can you briefly summarize the intellectual journey we've undertaken today?
We've embarked on a pretty fascinating exploration of Phil Hart's interpretation of the Constitution and federal tax law. It's a specific viewpoint, but a detailed one.
We definitely went deep.
We've examined his arguments concerning the definitions of key legal terms like United States and income, the critical constitutional difference between direct and indirect taxes, the often dramatic historical evolution of income taxation in the United States, and his rather unique understanding of the scope and intent of the 16th Amendment.
And as we've emphasized throughout, our aim here wasn't to offer any legal advice or to endorse Hart's views.
Absolutely not. The goal was to provide you, our intrepid listener, with a comprehensive and open-minded understanding of a complex and often controversial perspective.
We wanted to unpack his arguments in detail and let you draw your own conclusions. No judgment, just exploration.
Precisely. And on that note, here's a final thought to ponder, something that wasn't directly discussed in the book maybe, but resonates with the underlying themes. Thomas Jefferson famously said that the people should bind government with the chains of the Constitution.
A classic Jefferson line.
Reflecting on our discussion today about Hart's arguments, it prompts us to consider just how strong, and perhaps more importantly, how clearly understood those chains truly are in the context of modern federal taxation. Are they holding? Are they even visible?
A truly thought-provoking note to end on. Food for serious thought. As always, we encourage you to delve deeper into these ideas, conduct your own research, read Hart's book if you're curious, read opposing views, and engage in informed discussions.
Absolutely. Critical thinking is key.
Understanding the foundational principles of our Constitution, or at least the debates around them, is crucial for every citizen. Thanks for joining us for this deep dive.
Thanks, everyone.
Until our next exploration, keep those critical thinking gears turning.